duration, and any other manner in which the comments are made. And you can also require a sign-up sheet, so you can document who is participating. Notices of the board meetings are governed by the bylaws. The statutes do impose default notice requirements if the bylaws are silent. Notice should be posted at least 2 days in advance, or, and that's in a conspicuous place, or it may be mailed to your members at least 7 days before the meeting. Keep in mind that requirement does not apply in emergencies. For communities with over 100 members, you can also broadcast your notice. There are specific requirements related to that, which govern how often you need to broadcast the notice every hour, and how long it needs to be on the screen so that your members can comprehend the content of the notice and the agenda. Electronic notice is permitted, but members must give you written consent in order to receive electronic notice. Sorry, I'm moving my screen around so I can look at the slide a little better. Board members cannot vote by email. They can discuss, but they cannot vote. Here we are again with the association's ability to provide email notice to unit owners. Again, you can do that, but your owners must have consented in writing to receive such notice. There are specific agenda items that require heightened notice. Assessments. Assessments may not be levied at a board meeting unless they are specifically referenced in the notice. The notice also has to describe the nature of the assessment. With a special assessment, members are entitled to 14 days before the meeting at which those will be considered. And amendments to rules on parcel use also require 14 days notice. Right, board members, when voting at a board meeting, cannot vote by proxy or by secret ballot, with the exception of the election of officers. All votes must be out in the open so that your members know how you voted. The association must maintain minutes of all board meetings, member meetings. These must be maintained in a written form or in another form that can be converted to writing. Minutes must reflect either a vote or an abstention for each matter voted upon. The association must maintain official records for 7 years. On your screen is a list of the required documents. You can see here, this is your governing documents, your meeting minutes, membership rosters, insurance policies, plans and permits, contracts, and financial documents. Additionally, there is a catch-all in the statute requiring the association to maintain basically any written records that aren't specified here that are related to the operation of the HOA. So it's pretty broad. If in doubt, hang on to that record. And I should note that does include emails. Not all records are accessible to members. Records that are protected by the attorney-client privilege or the work product privilege are not accessible. Information obtained in connection with approval of a lease or transfer. This may include a background check or a credit report. Personnel records are not open to inspection. However, members can access written employment agreements and other budgetary or financial records that would reflect the compensation paid. So that's you can't completely hide that information if it exists in another document. All right, medical records of owners and residents are not available. Personal identifying information, not available. We want to protect your privacy. Electronic security information is not accessible. We do not want the HOA's sensitive passwords out in the community. And software and operation systems used by the association that allow the manipulation of data. The data is part of the official records, not the system itself. Official records must be made available to an owner for inspection within 45 miles of the community, or within the county in which the association is located. They must be made available 10 days after receipt of a written request. You can comply with these requirements by making these available on your association website. If the association has a copy machine, you must provide your owner with copies requested during the inspection up to 25 pages, after which you can charge a fee. A member or their representative may also bring a personal copying device, and if they do that, you cannot charge a fee. Did I skip one? There we go. The association may adopt rules governing the frequency, time, location, notice, the records to be inspected, and the manner of the inspection. You can also impose fees to cover the costs of the copies and the personnel that retrieve those copies. You'll see there is a limit of $20 an hour, and you've got that 25-page threshold before you can start charging. You can charge up to 25 cents per page. You cannot require a parcel owner to prove that they've got a valid reason to inspect the documents. They are entitled to inspect the documents, period. You also cannot limit the owner's right to inspect the records to less than 1 8-hour business day per month. If the association fails to provide access within 10 business days after receipt of a request that is submitted by certified mail, a rebuttable presumption exists, or presumption arises that the association willfully failed to comply. Again, that's a rebuttable presumption. You can prove that there was no willful compliance, but be aware of that. Members who are denied access can recover damages for the association's failure to share those records. Oh, it looks like I am passing it on to Troy at this point. He's going to talk a bit about budgets and financial matters.
Okay.
Thank you all for your attention.
Thank you, Barbara. All right, I'm going to share my screen here just a second, and we are, bear with me for 1 second. Okay. So we are here to talk about one of the fun parts of your fiduciary responsibility. First, I just want to say, with Southern States Management Group, we've been in business for over 30 years, and I've been doing this for 11, almost 12 years now. And one of the things that every board member should always recognize is there is an element of this role that as a board member that should be taken very seriously. Our methodology, what we try to invoke on our boards and our associations that we have the opportunity to manage is, an association is a business and it should be run like a business. The business has shareholders. The shareholders include the association members, which you are an association member, and the opportunities and the decisions that you make and the best practices that you implement, they affect shareholder value, which is basically your property value and the condition of the condominium. And the financial element is one of the assets. It's not a physical plant asset, it's not a pool, but it's one of the assets of the association that is very important to the viability and success of the association. So the common thread in the financial portion and budgeting is that each of you should remember that you're making decisions on behalf of the shareholders, and those decisions should be backed with information and implement historical knowledge and future knowledge, and utilize the best information and put it in place and take care of it and analyze it along the way, so that you will continue to best serve your community. So one of the main things that you're going to face every year, and you're going to talk about it all year long, is your budget. And most associations have some type of reserve element. So it's important that as you adopt your budget, the association will always consider reserve accounts. So if you do not, when you adopt your budget, there's certain, basic fundamental things that need to be implemented. There's language on the screen now that, basically says if you are not providing reserves in your budget and have, identified deferred expenditures, you need to put this language on your budget. It's required so that everyone knows that there's something that's not funded. Okay. So if you have established reserves, many of you are newer board members, or you're coming back to the board, and so if you have reserves, and then the thought process is, hey, we want to discontinue funding reserves, and you can do that with a membership vote. Okay, and I'm not going to read verbatim each of these slides, but you can do that with a membership vote. And it basically is something that you're going to have to do every single year. You can't just waive reserves and then just move on year after year after year. You're going to have to continue to do this each year that you're doing that. Okay. So there's a main component to the reserve methodology, and that's you have these assets, or this basis for accumulating a certain dollar amount.
Troy, I'm so sorry to interrupt. It's Diane. Can you just hit view slideshow?
What
We can see it's in, and thank you everyone for your patience very briefly. So this, I'm seeing it kind of like in the edit view, which we can see. It's just going to be a lot smaller.
Okay. Better?
Yes, that's perfect. Thank you.
Sorry about that. Okay, so the go back here. Okay, we're on here. So there's two methodologies, as I was saying. So you have this basis for funding a total amount. You have a roof and a pool, and maybe some an entry gate feature. And so all of these things have a dollar amount or a value, a total amount to replace them, and they have a useful life. And so you can establish a basis for funding these separately. So round numbers, let's say you have $10,000 gate replacement, and you have $20,000 pool replacement, and you have a $40,000 roof and clubhouse type replacement value. So if, for round numbers, let's say, each of these has a 10-year useful life. So you're going to divide 10 years into each of those numbers. So when it comes to the gate, a $10,000, you're going to put $1,000 away over 10 years to replace that. Pool, a $20,000 pool, you're going to put $2,000 away over a 10-year period, and the roof in the clubhouse would be $4,000 over a 10-year period. And so, you know, basically you're putting $7,000 away every year. And sometimes, you know, the useful life of these things, they go a little further than the, you know, the planned out 10 years. There's a basis for you to gather that information. That would be, you get 2 or 3 vendors out, or 1 or 2 vendors out, say, what's the condition of the roof or the pool or the gate? How long is it going to last? And what's the replacement cost? And you do that every 3 years, and you would adjust what your funding level would be based on new information. And each year that you would re-identify the amount, you would maybe use a cost index and escalate the pricing maybe 3% just for you know, inflation and those types of things. So so back to the example. So $7,000 sometimes is a big number to take on. And so the second methodology would be to have a pooled amount. So maybe you would combine the pool and the clubhouse all into one, and then you would maybe have the gate as a separate thing. So we're going to show you a couple examples here in a second, but the pooled methodology would blend 2 of the elements so that you may have a longer period of time to fund those things, because the roof will probably outlast the pool. So we're going to show you that here in just a second. All right. And if reserves, a reserve account is not established, and you know, these are you know, these are all things that the association, unless it's completely brand new, should be well down the road with. But you know, the slide here is, if you don't have a reserve account established, again, you need to have language on the bottom of your budget. And I'm going to stop here and say one thing. What we always like to advise our associations is, when it comes to whether it's covenant enforcement or something that a service you're providing to the community, or funding a reserve, the association's best day is whenever you're questioned or asked, why are you funding these reserves, or why are you accumulating this amount of money for this common element? The best day and the best answer as the association is to say, is because the documents say so. You know, there's nothing arbitrary about what the association and the business of the association should be doing. It's not because we feel like it, because the membership really pressured us and we know we're not supposed to, but we're afraid of them, or whatever. It's because the documents obligate you to. And if you're not doing something and you're questioned by the membership, again, the best answer is because the documents say we can't do that, or the Florida statute says we can't do that. And so as you make these decisions, as you analyze the reserve, whether you have reserve or not, your documents are, in the Florida statute, are going to be where you answer the question, why aren't we, or why are we doing this? So hopefully that makes sense to everyone. Okay. The reserve element, like a budget, you know, you're taking $1 and you're putting it in a bucket for operations, and the reserve, you're putting it in a bucket for reserve, and you're designating those reserve dollars for certain things, whether it's a straight line or pooled methodology, just like we just talked about. So if you're collecting assessments and you're collecting $1 for reserves and, you know, $10 for the operation, that $1 that you've collected for the reserve goes in that reserve bucket, and it can't be used for anything else other than what you've designated it for in that pooled reserve, or that specific element like the roof. Okay. And then there's some language there related to developer controlled association. If that applies to anyone, there's just specific things that the developer can and cannot do, all defined by the statute related to reserves. Okay. Now, each year the association is going to go through its fiscal year. It's going to have a year end. And in 99% of the time, that's maybe not 99, but 90% of the time, that's December 31st. And you have to report to your membership. The reporting requirements are based on dollar amount thresholds. And so you can kind of look at each of those. And so you want to look at what your total budget is. So your budget for 2020, identify what the dollar amount is. And then within those thresholds, you can see what type of reporting requirement that you have. And so, again, each of those would apply to different associations. The larger the association, the more stringent and the more thorough reporting you have to do, like an audit and those types of things. Okay, and so you have this requirement, you have this obligation to produce this document to your membership, and here's the timing of it. After the close of your annual date, you have 90 days to have it available, and you have to, within 21 days after it's completed, you need to identify that it's available, and whether you post it on an owner portal or mail it or just give them a notice to say it's available, let us know if you want a copy. And that's something that you are obligated to provide at no cost to the association member. Okay, so each of the reporting requirements have certain elements to them that would allow the association to fulfill its obligation. So there's a list of specific things that the association is going to navigate through during the year, and you need to provide a report and receipts and all of the backup information related to each of those elements there. Okay. And if the association membership would like to, if they're in one of the lower tiers of reporting, and the membership would like to have something that's more thorough, there is a provision in the statute that the membership can petition the board and require them to hold a meeting after 30 days of the petition to have a vote and have the membership obligate the association for that year to have a higher reporting requirement. Okay, again, statutes protecting association members. If there's questions and there's mechanisms in the statute that would obligate the board to report to the membership at a higher level if they follow those procedures and steps. And the board, as a board member, when you're petitioned, you have to react. Catherine and Wright Casey will speak a little bit more on some of those things later, like records requests and things like that. But this is one of those things when the board receives a petition, you have to react, and here's what you have to do. Okay, and so after that meeting, when you have a heightened financial report, again, you have 90 days to create that report, get all the information, and make it available to the membership. And then they have to have that report and put in, again, here's what, each of the elements that the association needs to make available when the heightened financial report or the modified financial reporting was approved by the membership. Okay, again, each of these slides are applicable to each of the individual associations based on their initial thresholds and then the heightened reporting petitioned requirement from the membership. And that looks like the end of my slides.
Okay, so we're going to transition into emergencies and some other board powers. And emergencies used to be something that someone would talk about and people only got excited about during hurricane season, or as we would head into hurricane season. Well, this year, emergencies sort of took on a new life because coronavirus was a declared state of emergency for the state of Florida. And so emergency powers were activated this year with coronavirus, which is the first time since the emergency powers statute where I think people have applied them broadly throughout the state in a context other than a disaster declaration from a hurricane. So the emergency powers can be found in Florida Statute 720-316. It just allows some flexibility in the event of an emergency. So you can conduct a board meeting or membership meeting after providing notice in a manner as soon as practicable. So I know some folks had their annual meeting right after the coronavirus disaster declaration, and we're not going to meet, in person with groups more than 10. Well, what do? Well, you can postpone your meeting because that's an emergency power. Normally our annual meetings, the date of that is very sort of sacred, and if it's in your bylaws, maybe as a specific date or a specific month or week that we have it then. But because of an emergency power, we can delay that. We could have held it telephonically or via Zoom. People are doing a lot of flexible things right now, and I think that's really, really great to see. Again, you can cancel and reschedule association meetings. If your officers are spread throughout the state, and I see this particularly with hurricanes, but it happened for my associations with coronavirus as well. Maybe your officers went to another part of the country to take care of something, and you need someone boots on the ground. And so you can designate an assistant officer who's not a board member. If you need someone to take minutes, you can designate an assistant secretary for a meeting for that person to call in, for example. You can also relocate the office of the association if you need to. And these are more focused. These are also enumerated emergency powers in the statute, really more hurricane related or disaster related. Enter into agreements with municipalities relating to debris removal. In the last few hurricane seasons, we learned that those of you with private roadways may not get collected when the cities come and pick up the hurricane debris. So you may need to contract with the municipality. You may need to contact directly with a debris removal company, because otherwise you're going to have a lot of debris sitting on the side of your roads, and your owners are not going to like that at all. Same thing, implement disaster plan. We have a whole separate presentation that we give about disaster planning. And so if that's something that's interesting to your association, I'm happy to go through that. I know Southern States is very well prepared on those topics as well. So if you're a Southern States managed property, you may want to talk to your manager about reviewing a disaster plan. Again, if something is unavailable for entry or occupancy, we typically we're thinking maybe your clubhouse got damaged in a hurricane, but maybe you wanted to shut down your pool. Maybe you had a gym fitness center and you had to shut that down. Those are coming back online this week. One question I was getting a whole bunch was whether or not you have to follow the state guidance and rules. Well, the state guidance and rules are sort of a floor. So if the state guidance and rules say pools are closed, which they never did, they said gyms are closed. Let me use gyms as an example. Gyms are closed. You can't open the clubhouse gym. But if now that gyms are coming back online, the board has the ability to make that decision when and how to open up the common property. Again, you can make it fully open if you think that is appropriately safe and it complies with the state guidelines. Or you can say, you know what, we're going to limit the hours. We're going to limit the number of people that come in. We're going to add all these additional, machine wipe downs, whatever it is. Make sure that your association property is available to be entered. And any kind of debris removal. You can levy assessments without owner approval. A lot of your documents allow you to do this anyway. A special assessment, typically, most modern documents allow this with a board vote. But if you have documents that require owner approval for assessments and you need to levy an assessment to do something related to the expense of an emergency repair or some other emergency power, then you can do that without owner approval. And you can also borrow money and pledge association assets. Never forget that banks are fairly interested in loaning money to associations. If you have a project, a lot of my associations get very leery of this, and it may not be something you're interested in. That may not be something you want to do, but people don't think, oh, I could go get a loan for this and repay it with a special assessment or an assessment instead of doing a giant special assessment. So want to make sure you know that's available to you. A couple other rights, responsibilities of officers and duties. Education is required. So you are required to go to a continuing or a board member certification class once in your time on the board. You only have to do it once. So if you are brand new to your board, check you have fulfilled your obligation. We're going to email certificates after the course, and you have fulfilled your obligation to attend a board certification class. If you stay on the board for the next 5 years, you don't have to go to another class. Now, almost all the classes put on by all the providers are based on the Florida statutes, and the legislature tinkers with those every year. Every year there's a change or two that comes out, some years more than others. So you may want to go to more classes. Or I find that the first time you take this class, it's kind of drinking from a fire hose. It's, oh my goodness, this is so much information that I'm learning. I want to go to another class. But as long as you're continuously on the board, this class will satisfy what you're required to do for the board. Now, if you leave the board and come back, you have to do a new class every time you come back. If you don't certify that you've been to a class, or if you can't find the class or you don't want to go to a class, you have other board members that haven't done the class, the thing they need to do is certify in writing that they reviewed the documents in Florida statutes. And so if you have board members that haven't gone to a class or haven't reviewed the documents in the Florida statutes, then that board member can be suspended from the board. And I don't really like that. That's not a game that I want to encourage you to play, to go, you know, you're suspended, you haven't done your class. I want you to encourage your fellow board members to take a class or to read the documents, because I think you get a lot out of it. Conflicts of interest. We get this question fairly often. What is a conflict of interest? How do you avoid them? What do you need to do if you think one comes up? If the association is entering into a contract or a transaction with a third party where an officer or director is financially interested, so if you own a lawn care company and the lawn care company puts in a bid to do the association's lawn care, you know, that needs to be really fully disclosed. We don't ever want anyone going back later and thinking, wait, was there a conflict of interest? And did that board member vote? Completely impermissible for a board member to vote on an item for which they have a conflict of interest. So the general rule is to disclose, and it may be, this is my cousin's nephew's sister's best friend's neighbor growing up's lawn care business, and it's not a conflict, right? That's not something that you're financially interested, or you have a family member that's financially interested. But if you disclose it, at least people know, and people can say, oh, that's not a conflict. It's also not a conflict of interest to do something where it benefits a board member along with other neighbors. So I hear all the time in associations with some ponds, and they want a fountain. Well, of course you want a fountain. Your house would be near where the fountain is. It's a conflict of interest. That's not a conflict of interest. You know, we're looking for a financial benefit specific to that individual board member. So you need to disclose the conflict of interest to the board, and then the board is going to have a vote without the conflicted director participating in the vote. It also needs the conflict needs to be disclosed to the members, and the members can undo any board contract where there has been a conflict of interest. Even if all the board members who didn't have a conflict voted for it, the members can do an override, right? So you want to think you want to think very carefully about that. I had some board members who say, you know, I want to do business with the association, and that business is so valuable to me, I'm going to step off the board, which is a perfectly fine thing to do. And the association is going to be liable for the value of the goods and services if the members vote to cancel the contract because of a conflict. But there's not going to be cancellation fee. You're not going to pay the rest of the contract. You're going to pay for what has been provided already, services. No kickbacks. So that means no financial benefit, again, to the individual board member. So if you award a contract to an irrigation company, we're not going to see gift cards, cash, discounts being given to the board members who voted for that or their family. And sometimes this can happen kind of innocuously. Oh, let me give you a discount on irrigation services. I'm just using irrigation services as an example. Let me give you a discount on irrigation services for your individual property. We're so appreciative of you contracting for the entire association. don't do it, right? We don't want any financial benefit for you or your family. I jokingly say, there's no benefits to serving on the board. Of course, there are a lot of touchy-feely, feel good, do the right thing, help your association out, be fiscally prudent benefits. But no one's getting any kind of financial benefit from serving on the board. If a board member has violated any of the conflicts of interest or kickbacks, that board member can be immediately removed from office with the vacancy to be filled until the end of their term. It is also impermissible for a board member to be charged with felony theft or embezzlement. So if a sitting board member is charged with theft or embezzlement, that person is removed from office. Doesn't have to be a conviction, doesn't have to be a guilty plea, charged is enough. So we want to get that person off the board. Now, if the case is dropped, or if the case goes to trial and the person prevails at trial, they can come back on the board. But if they still have the case pending, or they're found guilty, or they plead guilty, then that person is ineligible to serve on the board. Another thing to think about for officers and directors is that the association is going to have insurance for the officers and directors. So you're going to have D&O insurance, or you're going to have a bond in the amount to protect people who are dispersing funds of the association. So typically your president and your treasurer are covered by the bond. And that's something that you want to discuss with your insurance agent for the association. The association is going to pay the cost of insurance or a bond. It can be waived by a majority of the vote of the owners. Don't do it, right? If you can in any way afford this, get insurance that protects the board members. You cannot be compensated. But again, if everyone in the community is getting some sort of benefit, if we're returning an overpayment in assessments, or let's say recovered insurance proceeds and everyone got a discount on their next assessment, right? Anything that is for the community and people who are not on the board are getting the same benefit, that's not a precluded compensation. But we don't want directors, officers, or any of your committee members getting a compensation from the association. Now, a board member can be recalled, and there's some confusion about, well, is this removing a board member for doing something wrong? No, board members are elected by your owners, and the owners have a right to remove a board member for any reason, no reason. They don't like the job they're doing, they don't like the personality, you could do everything right, and you wore a blue shirt on Tuesday and a whole bunch of owners don't like that, they can start the recall process. Now, the recall process is fairly difficult, and so I don't see it all that often. It doesn't come up too often. You hear about, oh, the owners want to recall this board member, but it's a trickier process. You have to have either a ballot or a meeting with a majority of the voting members voting for the recall. You can recall either a single board member or multiple board members. If less than a majority of the board is recalled, the remaining board members can fill those seats. If a majority of the board is recalled, then the owners fill the seats. And if there is a proper recall process by the owners, the board has an obligation under Florida statutes to respond, to accept the recall, or to file a petition with the DBPR, Department of Business and Professional Responsibility. DBPR does not get too involved in HOAs. They're fairly involved in condo world, but not as much HOAs, except in kind of election disputes or recall disputes. There are a few requirements for association contracts when they need to be in writing. So, Bob's tree trimming is going to come out and trim one tree one time. We don't have to have an extensive contract. We don't have to have any written contract, right? $50, trim a tree, done. But if you're having a multi-year contract or services being provided, that needs to be in writing. So if we're having, Bob's tree trimming coming out twice a year for the next 3 years, we're going to want that in writing. We're going to want to see contracts for the provision of services, maybe landscape comes to mind. You're going to want that in writing. That's not a handshake kind of deal. And certain contracts have to be competitively bid out. So if it's in excess of 10% of your total budget, that needs to be a competitive bid process. Now, when the bids come in, the board is not required to accept the lowest bid. Maybe you like the services provided or the quality of the product or the service from one company who's not your lowest bid, or for whatever reason you don't like the lowest bid. You can accept any of the bids that come in, but you have to bid it out. And then the bid documents get kept as part of your records. There are a few contracts that are not subject to being bid out or even put in writing. If you have employees, so many of you now use all independent contractors, but if you had an employee, that doesn't have to be in writing. Also, your professional services don't have to be bid out or put in writing. Although I know some of you still do have written agreements or do those in bid. It's fine to do it. You just don't have to. So it's your attorneys, accountants, architects, your management company, your engineers. And older contracts, Florida statute didn't require them to bid out. If your management contract is 3 years, you do have to have a competitive bid. So remember I said management doesn't, that's if it's a single year or 2-year contract, but if you're gonna go for a 3-year management contract, that needs to be competitive bid. And again, does not apply to emergencies or if only one source is available within the county. We get a lot of questions, well, more than one source is available within the county, but only one person responded. Can we just accept that bid? I really advise you, if you only receive one bid in response to a request for bids, if you have time, send that request out one more time, just so you can say, you know, we really tried to get multiple bids here. We tried more than once, but we only got one bid. Bulk communications, again, more of a condo thing, but some HOAs still have neighborhood cable agreements or other kind of bulk contracts. And the membership can cancel those, and anyone with a hearing or blind disability can opt out. They don't have to be forced to accept the neighborhood cable. And a parcel owner may not be denied access to alternative providers, even if you have the bulk cable agreement and you want to use a different cable provider or a dish, you can do that. This is my favorite topic, architectural control. Basically, my rule of thumb is if you see Chip and Joanna do it, or on formerly Fixer Upper or any HGTV or whatever their new show is going to be, right? If we're changing the outside look of a lot, of a house, probably going to need architectural control approval. Architectural control approval really depends on your individual documents. There was a case not that long ago, I think maybe where someone was changing some landscaping, and the language in their documents only dealt with buildings, and the house didn't have anything to do with landscaping. And the court said, if your architectural control does not extend to landscaping in the documents, you don't have any right to restrict landscaping. So if it says, you know, rules about fences, that may not apply to landscaping, or rules about buildings may not apply to landscaping. So we're heavily going to rely on what your documents say. And the ideal would be if it's in your recorded declaration, right? If it's in your recorded declaration, a court's going to enforce that. The HOA is able to really enforce that well. If you have published rules, those have a little less authority than what the recorded declaration has in it. So if you have a list of colors that are good for painting houses and someone uses a shade that's slightly different, well, that's not one of our approved colors. It's a tougher fight, but it's still probably worth fighting. Certainly worth it, you know, when someone paints their house purple in an all brown and gray neighborhood. But if there's some confusion or there's no published rule about it, very hard to enforce those kinds of architectural controls. There are some things that no matter what your documents say, Florida statutes are gonna allow. No matter what your documents say, they say no flags, too bad someone's going to get a United States or state of Florida flag and a military flag on a flagpole that's less than 20 feet high. Also, folks are entitled to Florida-friendly landscaping. So that's not mowing the lawn, but that is, rocks, or you don't have to do St. Augustine sod necessarily, even if your documents say St. Augustine sod or St. Augustine grass. You may be able to use some other type of grass that is a little more native to the area. And there's a whole list of guidance on that. Also, access ramps. If the front of every house looks the same in your neighborhood, you can't keep someone from building a wheelchair ramp to access their house. And I hope that one's obvious. Although you can provide some architectural control over it to help it blend in if possible. You can display a sign for security services of a reasonable size. So that's how folks have their ADT or their Arlo signs. Can't prevent that. On signs, we get a lot of questions about what to do about, campaign signs. Campaign season is coming up. You really want to look at your individual documents and see what they allow. If they're silent, you're probably going to fall under your municipality requirements for signs. A lot of towns in our area say you can put a sign up 60 days out ahead of the election. I know some associations, their documents say no signs, but they have a history of permitting, political signs a month or two before an election. What you most want to make sure you're doing on signs, and political signs particularly, is not picking a viewpoint, right? So we're not going to allow all Biden signs and no Trump signs, or all Trump signs and no Biden signs. If you're allowing signs, you're allowing signs. If you're not allowing signs, you're allowing no signs. Now, owners are also allowed to peaceably assemble, meaning they can go into the common areas and recreational facilities. Of course, if you charge rentals or have a rental process, you can do that. You can adopt rules, but you cannot say, homeowners, you can't gather at all. You can't keep them from gathering either on the common areas or in other parts of the neighborhood. And you cannot refuse to allow public officers or candidates to come onto your common areas as well. And if an owner is exercising a First Amendment right, you can't sue them in what's called a SLAPP suit, right? You can't file a lawsuit against an owner who's simply exercising a First Amendment right. You can't try and shut them down. And we don't see this very often at all, but there's a fair amount of statutory language and cases about SLAPP suits. We're not seeing them here, but if we're advising our clients, make sure you have a real issue, and this is not a personal issue or someone didn't exercise a right they're perfectly able to have before you start taking action against them. And that's going to end it for my part of the presentation. Again, like everyone else, so glad you're here with us today, and happy to get to speak with you. I think I'm handing it off now to Aaron to talk some more about meetings and board action.
So Aaron, we just want to make sure that you're unmuted, because unfortunately when I hit mute all, you'll have to just undo it yourself, and you're good now. Thank you.
Okay, hopefully you can hear me and see my slideshow. So I'm going to continue the fun with talking about amending documents and meetings and elections. So I'm going to head right into amending the declaration. right? The declaration is your most important document, and to amend that document, there are actually only 2 statutory limitations on those amendments. So you actually have a very broad authority to amend your declaration. So the only 2 limitations by statute to your amendments are any amendments that might alter voting interests or that might increase an owner's percentage share of the common expenses. And so if you are making an amendment to your declaration that does either of those, you must have the consent of the affected parcel owner and any mortgagee that owner may have. So again, trying to get a lender to consent and sign on to a declaration falls into the bucket of an almost impossibility. So just be aware when you're amending your declaration or considering amending your declaration that you steer clear of any amendments that may fall into that category. As we're talking about amending your governing documents, so that's going to be all of your governing documents, your declaration, your bylaws, keep in mind that look to your documents first. Check your documents, because your documents are likely going to contain the procedure for amending your documents, what the quorum requirement might be, and of course what the rate of approval would have to be in order to get an amendment approved by your members. If for some reason, though, that your governing document doesn't specify those items, particularly quorum and the level of approval, either percentage of approval, then there is a statutory fallback that you would use. And so that's going to be found in Chapter 72306, and it provides a statutory fallback of a quorum of your members of 30%, unless you have a lower number in your bylaws. And to approve an amendment, it requires 2/3 of the voting interests. So again, look to your documents, but if your documents are silent, it talks about amendments kind of generally, but it doesn't give a very specific quorum or an approval rate, then you're going to be bound by this statutory fallback of 30% for a quorum and an affirmative vote of 2/3 of your members. When you amend your documents, or when you propose to amend the documents, right, you want to send those to your members so that they can see what it is that's being proposed. And by statute, you need to do that in a fashion that allows owners to really see what the changes are, right? The declaration is a big document, and it can be confusing, especially to owners who aren't, like when you're on the board, you become very familiar with these documents, but your average owner who's not on the board, hopefully they read the declaration before they purchased, but many do not, unfortunately. And so the statute is going to say, if we're going to make changes to this very, very important document in our association, we want to be absolutely certain that members know what is being changed. We're not going to try to slip something in. And so the statute says that if you are adding new language, when you send that to the owners, that new language has to be underlined. And if you're removing existing language, then that wording must be stricken. We're going to use the strike through for those. If you are doing a pretty extensive amendment to your documents, then you're going to fall into a bucket called maybe something along the lines of an amended and restated declaration, right? You're really changing so much that it would be confusing to members if we tried to do the underlining and the striking. So what we're going to do is the statutes require that you have this sort of notice on the document that says substantial rewording, see governing documents for the current text. So either way, that amendment, if you get it approved, it becomes effective when it is recorded. Luckily, the statutes are going to also provide a little bit of a saving grace. If an immaterial mistake is made in the process in amending the governance, not something substantive, but you forgot to do something exactly right, then that's okay. The statutes are going to say it is not going to invalidate an otherwise properly adopted amendment. So that's good. The statute's also going to say that if you are mailing a notice to unit owners, right, we're going to send out the proposed declaration amendment. The statute's going to requires that document be mailed or delivered to the address identified as the parcel owner's mailing address on the property records. And just a little practical tip here, you know, your owners sometimes have multiple homes, and so they live in your community for a few months out of the year, live elsewhere, they may have multiple homes, they may even have all of their mail going to a post office box somewhere. So one practical tip is maybe once a year at the beginning of the year, have someone on the board undertake that to just review, pull up the addresses in the community, make sure that your roster, your mailing roster, not only sends notices to the parcel, the lot that's in your community, but also whatever the owner has on the tax of Volusia County property appraiser's website as their mailing address, that by statute is where you need to send that as well. So just be cautious about that. And after an amendment is approved, the statutes require that you need to provide a copy of that amendment to your owners within 30 days after recording. There's a little caveat there that if you had provided a copy ahead of time, pre-approval, then you don't necessarily have to send another copy, but what you do have to send is notice to your owners to let them know that it in fact passed, it was approved, that it was recorded. You're going to provide them the book and page number, and also let them know that a copy can be made available to them. So again, we just want to keep our owners involved in the process, because the declaration, again, is such an important document. All of the governing documents are important, so we don't want to even have the appearance of trying to slip something by some owners. Okay, next we're going to talk about meetings. And if you're new to board service, maybe you've attended some meetings in the past, but as an active board member, you're really going to come to love meetings. And that's said with some sarcasm. So we have different types of meetings. We have membership meetings and we have board meetings. And they are obviously two different creatures. The most important of the member meetings, and the one that's the only member meeting that is required, is the annual meeting. And so by statute, every association must hold one meeting per year. So if you live in an association, if you're very lucky and you don't have a lot of governance issues and things just kind of sail along nicely, you may in fact only see your members at the annual meeting, and that's nice. But that annual meeting, it must be held at the time, date, and place that's stated in your declaration. If there's nothing in your declaration, great, then you have some flexibility so long as you hold one each calendar year. But if your declaration says we're going to hold it, the annual meeting needs to be on the second Tuesday in February, then by statute, you need to do everything possible to make sure that that meeting is held on the second Tuesday in February. If it says annual meeting is on March 1st, do your best to do that, right? Emergency situations notwithstanding, but the biggest key to making sure that that happens is, of course, to plan ahead. So towards the end of the year, in the year prior, we want to go ahead and start calendaring the date. We want to calendar, make sure that we have enough time to send whatever notices or documents, especially if you're having an election, because again, your election of the board of directors happens at your annual meeting. And so you're going to need to get your candidate information out, whatever your documents say about the election, just be sure that you backtrack from the date that's in your declaration for the annual meeting to ensure that you have enough time. And you can see this is just a little cross stitch that I keep in my office, right? Plan ahead. Just keep this visual in mind when you're talking about that annual meeting. You want to be sure that it doesn't sneak up on you and that you're a month out only to find out that you have some requirements for notice and that you then can't hold that meeting when your documents say, and I assure you, you will have some owners who will point that out to you. So we don't want to be caught in that situation. Other than the annual meeting, you may also have special meetings for your members. And by statute, special meetings can be called by the board of directors, or if 10% of your owners want to have a meeting on a specific topic, then by statute, that is a requirement that that meeting be noticed and held. Okay, a special meeting is exactly what it sounds like, right? The special meeting is being conducted for a very specific purpose, and so we're going to make sure that our notice and our agenda and what we talk about at that meeting is exactly that specified purpose. Because you're going to have owners who get a notice that say, we're having a special meeting to talk about a new landscaping contract. Well, okay, they may not feel strongly one way or the other, and so they don't attend. We want to be sure that we don't then get to that meeting and start discussing and making decisions on any topic other than what we have noticed our members. Seems common sense. We're also going to have, so the notice of the meetings for your member meetings. Check your bylaws. More than likely, your bylaws are going to specify the type of notice that your members are entitled to receive before a member meeting. If for some reason your documents do not, again, there is a statutory fallback, and that is to provide your members with no less than 14 days notice before a meeting, and then you provide that notice by mail, hand delivery, or email. Your documents may also have a provision that either requires posting. So if you have a community billboard type area in your community, your documents may say, in addition to the notice that goes directly to members, a notice for a meeting has to be posted, say, at least 48 hours in advance. So just be sure that you have reviewed your documents, you know exactly what those notice requirements are, and that you follow those. The notice for the annual meeting does not have to have a specific purpose. It needs to have an agenda of all the items, but the actual notice of the annual meeting does not need to specify every single item that might be talked about at the annual meeting. Okay, so if you've properly noticed your meeting, your member meeting, now it's time to be sure that that meeting can be held, right? That we have enough quorum to actually hold the meeting. And again, check your documents, because you may have a lower quorum number in your documents, but by statute, the statutory default is 30%, cannot be any higher than 30%. So be careful of that. Make sure that your documents don't have something higher than 30%, and if they do, I've seen a few of those with my older associations. For some reason at some point they had amended to maybe require 40% or something. The purpose of keeping quorum low is, and as you know, right, it's often the biggest challenge that an association has is attaining quorum. So we want to make that as reasonable figure as possible so that we can conduct the business of the association. Voting, so you have your quorum, you're holding your meeting, and your members need to vote on something. Check your documents, but if your statutory fallback is going to be the majority of your voting interest, but your documents may say some form of supermajority is required, right? And so you want to be sure to follow those documents. Okay, proxy voting. Your members are entitled to vote by proxy unless your documents specifically prohibit that. So just be clear on that. We do get some questions from clients from time to time about proxies. To be a valid proxy by law, there's only 3 requirements. The proxy must include the date when the proxy is given. It must include information about the meeting for which it's given, specific information. It's the date, the time, and the place of the meeting for which it's given. It's specific to a particular meeting. And then it has to have a signature of the authorized person executing the proxy. So those are the only 3 requirements for a proxy. And we often get questions from associations who maybe they create a form of a proxy, right? When they mail out notice of a meeting and they tell the membership that we're going to vote on a particular issue, they include, right, a proxy. And that's fine, but keep in mind that if your owner submits a different proxy, but that proxy does include all 3 things that are required under the statute, then that's a valid proxy and it needs to be accepted. So don't take the position of saying, well, you didn't return our form proxy. I think that would be a problematic position to take. As I said, the proxy is effective only for the specific meeting that it was given for. So we're not going to allow in a general proxy for voting. And sometimes this gets people confused, right? You can't just give a blank proxy to your neighbor and say, here you go, anytime association business comes up, you vote for me. That's not how that works, right? You can give a proxy for attendance purposes, for quorum purposes, but for voting, it's for a very specific meeting if you are giving your proxy. Keep in mind that proxies are revocable at any time. Your documents, specifically when we're talking about elections of the board of directors, your documents may include the right for members to vote by secret ballot. Voting by secret ballot is not the same thing as proxy voting. So if your documents include a process regarding secret ballots, keep in mind that that's a very specific 2-envelope system where a ballot is returned in an unmarked inner envelope, and then the outer envelope is where you're going to have your owner's name, lot identification, and their signature, so that when we remove that outer envelope, right, we still have this the secret part of the secret ballot is maintained, and that's what's opened at the meeting and counted. But again, it's a different concept than proxy voting. Going back to meetings, if you're holding your meeting, you've sent all the proper notice, you've got your quorum, or let me back up just a minute. So you send your notice, but maybe you don't have a quorum, and you call the meeting to order, you don't have quorum, so you actually can't conduct the meeting. You can't conduct business without the necessary quorum, so you're going to adjourn the meeting. The important part of the adjourning the meeting is really that if you can, at that meeting, you want to announce the date, time, and place for the next meeting, for the meeting that's going to come. But if you can't do that, right, we don't know exactly when we're going to do that, then the statutes are going to require, of course, that you renotice the meeting, just to make sure that everybody who didn't attend or did attend the first time understands exactly when we're meeting to try again. Okay, so of all of my slides this morning, this is going to be the most painful, if that's the right word here, and that's because we're going to talk about owners' rights and the rights that your fellow members have, and that is the right to speak and the right to record. And these can be somewhat controversial at times, primarily the right to record, but I'm going to start with the right to speak. And again, by statute, your owners have the right to attend meetings and to speak on all items that are open for discussion or on the agenda. They are, by statute, provided a minimum of 3 minutes per item if they'd like to speak on those. Now, the board can adopt reasonable rules regarding this right to speak, right? And that can talk about reasonable rules regarding the frequency, the duration, and other manner regarding this right to speak. And I think it's a great idea to establish some of those rules. And importantly, if your association doesn't have a policy regarding the right to speak on agenda items at meetings, be sure that you do so at a time when it won't be perceived as being directed at what I like to call an active owner. All of your associations may have what's an active owner, somebody who's very involved. They ask a lot of questions, they request documents, and this active owner, right, if he or she starts attending meetings and exercising their statutory right, what you don't want to do is have it look like the association is now going to all of a sudden create this policy. So just be wary of that. This is a good time, just as you're starting your board service, to really dig into your documents, see what's there, and most importantly, see what's not there, and see what issues for governance that your community might want to consider. Okay, so back to my very painful slide, and this one is the right to record. And this is a somewhat misunderstood right. And so by statute, any parcel owner is permitted to record or videotape board meetings and member meetings. Again, the board is allowed, though, to adopt reasonable rules regarding taping. And I think that this is an incredibly important thing to consider, right? So you can, maybe your policy says that you have to provide advance notice. If you're going to videotape, you have to be at the back of the room, you know, off to the side. You can't be right up in the front row, putting a camera in the faces of the board members. So you can certainly consider creating a policy that gives your owners these rights, certainly, and allows them to exercise them, but in a manner that is not disruptive, in a way that is respectful for everyone else who is in the meeting. So I highly encourage that you do that.
Hi,
And
Darren, this is Barbara Reed returning your call. I'm doing all right. How about yourself?
So, and here's the aspect of this that we get asked sometimes, which is, well, I don't consent to be recorded. I don't, right? What if that video then gets put up on YouTube? And I certainly understand that that's a concern. The problem is, right, the meeting is a public meeting, public in the sense that there is not a expectation of privacy in that sense. So it is permitted, is all I can say. I know that it's unpopular and people are not happy with that. I think it's happening less. We get asked this question from time to time, but it seemed a few years ago is when posting to YouTube and those types of things was really happening, but we're hearing less and less about that. So hopefully that's not too much of a real concern. Okay, so the most important thing that your members do is elect the board of directors. And so the most important thing that the board of directors needs to do is try to get that process right. So when you're looking at the policy for how the election is supposed to proceed, you, of course, start with your documents. Start with your documents and see exactly what your documents require. Important here, and sometimes, you know, this seems common sense, but it sometimes gets missed. And that is, if you look down at the third bullet point on this slide, it says no election is required unless more candidates are nominated than vacancies exist. So if you have 3 vacancies and only 3 people put in, or only 2 people put in, then we don't have to have an election. We're only going to have an election if we have more interested people than vacancies available. And so if an equal number or fewer qualified candidates, I'm gonna come back to that in a second, qualified candidates, if we have an equal number or fewer, then those candidates are going to commence their service at the annual meeting, and that's regardless of whether a quorum is attained at that annual meeting or not. So again, if you have a community that has a hard time getting a quorum, reaching a quorum to have that annual meeting, what we don't want to do is have the business of the association just come to a standstill, right? So again, if possible, if the exact facts and circumstances permit, again, meaning that we've got an equal number or fewer candidates than our vacancies, then notwithstanding that we don't reach that quorum, those candidates are going to immediately start service at that annual meeting that is not actually held. So what are the qualifications for a director? So qualifications for a director, right? In addition to extreme patience, a thick skin, and a real love for late night emails for your owners, the legislature doesn't put specific qualifications. Your documents may contain some qualifications, but by statute, there are only 2 specific ways that you would be ineligible, that a person would be ineligible for service as a director. And the first is any delinquency of 90 days or more, 90-day delinquency of any fee, fine, or other monetary obligation due to the association. I'm going to highlight monetary obligation. So it's a fee, fine, or monetary obligation. That monetary obligation is pretty broad, and so that's going to include things, of course, assessments, but also interest, late fees, and attorney's fees. So if you have an owner who has a dispute with the association. It doesn't feel that they owe an assessment. They don't feel like they should have been assessed interest or late fees. You know, the matter shouldn't have gone to the attorney's office. And so they have these other charges on their account. If that has been in place for 90 days, then that person is going to be ineligible to serve for the board. And if after you become eligible and after you are on the board, so if at any time during your service on the board, you become 90 days delinquent in any fee, fine, or monetary obligation to the association, then the statutes are going to say that you have abandoned your seat. That creates a vacancy, and then that vacancy would be filled by a majority of the remaining members. Also, and Catherine, I think, touched on this a little bit, if convicted of a felony. So if you're convicted of a felony, you are ineligible for service unless civil rights have been restored for at least 5 years. Vacancies on the board, these will occur from time to time for a variety of reasons. Statutes are going to say, check your documents, you may have something different, but most are going to say that vacancy would be filled by a majority of the remaining directors, and the person who fills that vacancy does so for the remainder of the unexpired term of the person, of the seat that they are filling. If you have any disputes regarding the election, and Catherine touched on this, you have to submit that within 60 days to the DBPR, and they will assist with that. If a community fails to fill vacancies on the board for any reason, right? What is an option is placement of a receiver. Florida Gators receiver, excellent. But a court-appointed receiver, not so good, very expensive. So just be aware of that with your association. If you have vacancies, you have an obligation to fill at least enough of those vacancies to establish a quorum. And because if you don't have a quorum of the board, you cannot conduct business. And at that point, any of the owners can petition the local court to place a receiver, so that the association business can go on. But of course, the placement of that receiver, there's compensation involved, and so it gets expensive for your community. And that's the end of my portion. Thank you so much. I'm going to turn it over to Brooks Casey.
Hello, everyone. Let me get the screen up. Aaron, you need to turn yours off if you don't mind. There we go. Okay, so I'm going to be talking about the exciting world of assessments and what to do if you have an owner that isn't doing what they're supposed to do. And this is the last section, so I'll try to get through it quickly so we can answer some questions. I know we've had a couple submitted. As you know, since you already live in an HOA, you are required to pay assessments. Those assessments are supposed to be proportional to the neighborhood. You can have regular and special assessments, and they can vary if your documents provide for that. But generally, everybody's share should be consistent and similar as outlined by your documents. The important thing about assessments and collecting on them for the association is that the association has a lien on any property within the association. The lien is effective from the date of your original declaration. So that means that if anybody gets a second mortgage or things like that, your lien will be superior. First mortgages, though, do have priority. Excuse me for a second. Sorry about that. Sorry. Your lien is required to have these items on the screen. Sorry about this, guys. I am not feeling well all of a sudden. But let's see. So you're supposed to have these items on the screen: description of the parcel, name of the owner, name and address of the association, assessment amount, the due date, and that the claim of lien secures all unpaid assessments that are due and may come due subsequent to the recording of the interest. The owner, if a lien is recorded on the property because of non-payment of the assessments, the owner, if they then pay it, has a right to have that satisfaction of that lien recorded. And if they dispute the amount of the lien that is recorded on their property for non-payment, they may record a notice of contest of the lien, and that makes the lien expire within 90 days if the association does not file their lawsuit. Once you have a lien on a property, if the owner isn't paying, you have a very powerful right as the association to bring an action to foreclose the claim of lien. If an owner isn't paying, a lot of associations set out a timeline for where they say, okay, we're going to let owners go for 30 days or maybe 60 days, but then if they don't pay, we're going to consider what we need to do to foreclose on the claim of lien. In addition to foreclosing on a claim of lien, the association can bring an action to recover a money judgment for unpaid assessments. You might do that if you know that an owner's house has a big first mortgage on it, but you know that they have some other asset like an expensive vehicle or an expensive boat. And if you get a money judgment, you can collect against that boat or that car or whatever asset you know that the owner has. So sometimes recovering a money judgment may be better than a foreclosure. In bringing that action, the association is entitled to recover all of its attorney's fees incurred in bringing the action to foreclose the money judgment or the lien or the money judgment rather. And if the parcel does go up for an actual foreclosure sale, the association, if their judgment is enough to make it the high bidder, the association can become the owner of the property after the foreclosure sale. If the owner remains in the property after the foreclosure sale and the association is the owner, then the association can start charging that owner rent if they don't vacate the property, or they can ask the court to appoint a receiver to take control of the property. Every parcel within your HOA is liable for assessments. Those assessments that they're liable for are those that came due while that owner was the owner of the property. So if they sell the property, they stop becoming liable for the assessments from that point on. What they can't do is they can't sell the property to, say, their brother or their sister or their mother to avoid the liability, because as you can see in the second bullet point, parcel owners are jointly and severally liable with the previous parcel owner for all unpaid assessments that come due up to the time that they transfer title. So if you think you're going to get out of your assessments by deeding the property to your brother, for example, well, your brother is now going to be liable for all of those assessments that you owed, plus any that come due while the brother is the owner. So that is not a way to get out of what you owe. As I mentioned on the first mortgage, they do retain priority over the lien filed by the association, except under the safe harbor provision in the statute, if the association forecloses its lien, if a mortgage holder forecloses its mortgage and takes title to a property and there were a bunch of past due assessments, the bank or the lender, the first mortgage holder, only has to pay the lesser of what assessments came due in the previous 12 months immediately preceding the acquisition of title, or 1% of the original mortgage debt. So this is a protection given usually to banks who hold the first mortgage, so that if somebody hasn't paid their assessments for 3 years, for example, the bank will only have to pay the past 12 months. So it's a protection for them. And this came into play a lot during the last recession in 2007, 8, 9, 10. The banks were getting this less amount that they would pay, and the associations were having to eat a lot of past due assessments. Safe harbor only applies, though, if the first mortgage holder names the homeowners association in their original complaint. If they fail to do that, then even the bank will owe all of the past due assessments. Assessments and interest and late fees. If your documents do not provide for an interest rate, which most of them that we see does not provide for an interest rate, then the default interest rate is 18%. So if a homeowner isn't paying, and the association can tack on 18% interest, which is pretty stout. The association can also charge administrative late fees of up to $25 or 5% of the amount of each installment if it's authorized by your declaration or bylaws. So if it's not in your declaration or bylaws, you shouldn't be charging a late fee. If your late fee is more than the amounts here, you shouldn't be charging greater than the amounts that are provided for in the statute. When an owner gets behind, a lot of times what happens is the association sends them a letter, you tack on interest and perhaps the late fee, and what happens is a lot of association owners will run down to the manager's office and pay their assessments immediately, but they won't include the interest and the late fees, or if an attorney wrote the note, they won't include the attorney's fees. So what the statute provides is that when you receive a payment like that, you apply the payment first to interest, then to late fees, then to costs and attorney's fees, and only then to the delinquent assessment. If you, if they think they're going to run down and pay the assessment and escape liability for the interest, late fees, and costs, they're not, because when you tally this up, there's still going to be a balance of their assessments left due. So there is not a way for them to get out of paying these things if they're already late and in default. And that's basically saying the same thing, except that there are some other laws that talk about how you apply payments. They do not apply in the case of HOAs. The HOA law supersedes it and says you apply payments first to interest, then late fees, then to costs and attorney's fees, and only then to the assessments. So that's a powerful protection for the HOA, that the HOA doesn't have to incur these expenses themselves without the ability to recover it from the owners. So when you have an owner who isn't paying their assessments, you have to follow the statutory procedure in order to place a lien on their property and ultimately to foreclose. The first thing that you have to do is you have to send them a letter that they are delinquent, and you have to give them 45 days to pay that lien or pay that amount, or a lien will be filed. It has to go by certified and regular mail. You have to do that first, and you do that usually through your attorney. The second demand that has to go is if after 45 days from the first letter they still haven't paid, now you have to, you would record your lien, and then you have to send them a second notice called a pre-suit demand, telling them that you recorded a lien and telling them that they now have 45 more days to pay, or a lawsuit will be filed against them for foreclosure. So already they've got at least 3 months, probably more by the time all of these procedures take place, to have paid their debt after being given notice. So if they still haven't paid it after 90 days, they're probably not going to without the next step, which is to file a lawsuit. An interesting benefit that Chapter 720 also provides to the association is where a tenant is occupying the parcel, the association can actually collect the assessments from the tenant directly if the homeowner isn't paying. Now, you have to provide notice first before you can do that. And this was a powerful tool back again during the last recession, because a lot of owners stopped paying their assessments and their mortgages. They put a tenant in there and they were collecting rent while the HOA and the bank wasn't getting paid. So the legislature put this into place where if a tenant is in the home, you can go to the tenant and you can collect their rent directly to the association. If they do not pay the rent to the association, then you can actually evict the tenant. And the tenant, if they do pay the rent to the association, is immune from claims by the owner for eviction and things like that, because they followed the statutory requirement. And this is basically explaining the same thing. Associations can file the eviction if the tenant fails to pay. The association, though, doesn't have to do anything that a landlord would do. Like if the dishwasher stops working, the association has no responsibility there. It's just that if the tenant refuses to pay the rent to the association, then you can evict them. You can't collect more than the rent from the tenant. So if the assessments are $1,000 a month, which would be unusual for an HOA, but if they were $1,000 a month and the rent was only $800 a month, you can't collect the $1,000, you would collect the $800 from the tenant. Estoppel certificates, you will become familiar with these because every time an owner goes to sell their property or maybe refinance their mortgage, then their lender usually, or the title company doing the sale or the attorney doing the sale, will ask the association for an estoppel certificate. Basically, this is a document that tells the mortgage company or the buyer how much in past due assessments are owed, and those have to be paid before the closing takes place usually. So these are important because you have certain timelines and requirements that you have to meet in order to give these to the requester. And the requester is the parcel owner or the mortgagee. A lot of times you'll get requests from people who are looking for deals on property. You know, somebody who's out there sees that a property might be in foreclosure and they want a deal on it, so they contact you and say, can I have an estoppel or a payoff? No. You only provide the estoppel or payoff for the parcel owner or the mortgagee. And like I said, usually that's when there's a sale or a refinance happening. You have to give it, though, within 10 days of the request, and you can charge fees for that. So the base fee is $250 if there are no delinquent amounts. If it's an expedited request, you can add $100. And if there are delinquencies on that account, you can add another $150. The estoppel certificate is supposed to require the following information, the information that's on the slide. It's the date of issue, name of the unit owner, the unit, parking or garage space number if they have one, attorney's name, contact information, fee for the preparation, name of requester, and the assessment information. If you have an owner who is doing something else in violation of your documents besides not paying their assessments, then there are certain steps that you can take. So you have, and this applies to not only unit owners or home owners, but it applies to tenants, guests, invitees, and the association. So if anybody's violating the governing documents, there are actions that can be taken. The association or any member can initiate a lawsuit based on failure to comply with the governing documents. And in those lawsuits, whoever wins also recovers their attorney's fees. And that's very important because oftentimes when we're talking about association disputes, the issue of attorney's fees becomes the most important part of the claim because they accrue so quickly. Attorneys are expensive, and you know, somebody may have done something wrong, like painted their mailbox purple. That's a violation of the rules, but we all know the attorney's fees are going to be a whole lot more money than the cost to fix the purple mailbox. So it is important to make sure before you waste a bunch of attorney's fees on a claim. Another option besides unit owners who aren't complying with the rules. Those fines can be up to $100 per violation, depending on whether your governing documents allow for fines. And then if it's a continuing violation, like the purple mailbox issue, then it can continue. It can be a continuing fine of up to a total of $1,000, as long as the problem is continuing. If your governing documents allow for it, it may be more than $1,000, but usually I don't see a lot of documents that allow for more than that. And then fines of $1,000 may become liens on parcels if your documents allow for that as well. Another option for enforcement of the declarations or bylaws or rules is that the association may suspend an owner's use of the common areas. Same for tenants, guests, and invitees as well. You can suspend their use of things like the pool or the tennis courts, things like that, but you can't suspend their ability to use things like the roads, if they're private roads, or the guardhouse, anything that relates to access to their home, you would have to allow them to continue to use. If you are going to fine someone or suspend their use of common elements, you have to follow certain steps in order to do so. You have to give them 14 days notice in advance of a hearing so that they can be there, present, and state their case. And then you have to appoint a hearing committee of 3 or more members. They're appointed by the board, but they're not officers, directors, or employees of the association, and they can't be related to any officers, directors, and employees. So they have to be independent committee members. The committee members then consider the case, and they have to approve the fine by a majority vote. And then if they do approve it, they have, there has to be sent out a mailing or hand delivery of the actual fine notice. The role of the committee is limited to just the issue of whether they are going to agree with the fine or reject the fine. That's it. They don't go into any other role. That's left for the board, and it must be by a majority vote. If the fine is approved by the committee, then within 5 days, payment is due. Suspensions, again, we talked about that briefly. When an owner is 90 days delinquent in paying fees, fines, or any other monetary obligation. So it doesn't have to just be assessments. It can be if they didn't pay a fine that you levied, or there's some other monetary fee that is owed to the association pursuant to your declarations, then the board can suspend the unit owner or the homeowner's right to use common areas, and they can suspend that owner's right to vote. But again, you cannot suspend their access to their home or to the neighborhood or anything like that. The notice and hearing requirements that we talked about for fines don't apply to a suspension, but it does have to take place at a board meeting that's properly noticed. So you don't need a committee to suspend somebody's common area usage rights, but you do need to have a board meeting item or agenda item about this. You can't just spring it on them that their rights have been suspended without having a meeting about it. There are alternative dispute resolution procedures provided for in the statute. In certain cases, you have to have an arbitration instead of going and filing a case in court. So those are when you have a recall of your board. In other words, members are trying to remove somebody from the board, or you have any election dispute. Those have to be submitted to binding arbitration. Then in most other disputes, except for those related to collection of assessments or monetary amounts, you have to have pre-suit mediation. And it's very important that you follow the requirements for the pre-suit mediation, because what happens if you don't is that if you ultimately file a lawsuit against somebody and you didn't participate in the pre-suit mediation, you have waived your ability to be able to collect your attorney's fees. So even if you filed suit and won, you would not be entitled to an award of attorney's fees because you didn't follow the pre-suit mediation requirements. And those requirements are that if somebody is violating the rules, you send them a mediation demand. I think it's on the next slide. Yeah. So, like I said, disputes that aren't subject to collection or to pre-suit mediation or collection of assessments, fines, or financial obligations, or disputes where emergency relief is required. For example, if somebody is building something that wasn't approved by your architectural review committee, you could file an emergency action to stop them before they finish. But if you are dealing with any other dispute and you've got to do the pre-suit mediation procedures, you send the written demand, and you don't want to ignore this. If you are the association and you receive a written demand from a member, they have a right to request pre-suit mediation too. So you have 20 days to respond to that pre-suit mediation requirement, and then the mediation must take place within 90 days of the demand. The parties share the cost for that, but then if you later have a lawsuit, the party that wins can recover their share of the mediation expense as well. Like we talked about, if you fail to do that, then attorney's fees are not recoverable. The Marketable Record Title Act is also called MARTA, is a confusing real estate statute that's been around for a long time. And basically it says that if you have a homeowners association and it's older than 30 years or at 30 years, your declaration will expire unless you take certain steps to keep it alive. And basically you want to keep it alive. You don't want your declaration to expire, because then your neighborhood will not be subject to any rules, and people can do things that may be incompatible with your association layout or aesthetics. So you want to do that, and you are required every year to consider whether it is time for you to to preserve your documents. 720.303(2)E requires you that at each of the first meeting of the year, or at the first meeting of each year, the board is required to consider whether or not you need to take steps to preserve your documents. It's a pretty easy process if you're under 30 years. If you go over 30 years and your documents have expired, it's a cumbersome process that requires approval from the members. So you want to make sure that you don't let 30 years expire. And that is all of the topics that I have to discuss. So I think we have some questions.
Yes, Brooks, I have some questions. I'm going to email over to you. We have 3 for you, one for Catherine and one for Aaron. So if it's okay with the 3 of you, I'm going to have Brooks address his that I'm sending over right now. And then we'll go to Catherine, then we'll go to Aaron. For all, if you have questions, again, go to your chat button, select to Diane Michael, and type in the name of the attorney that you would like to ask the question to. And also we have Troy Railsback from Southern States that's with us if you have a question for the management team as well.
So I guess I'll take mine first if everybody's okay with that. I have one that says, please address if and how the HEROES Act will impact HOA assessments. My understanding is currently, I understand that the House of Representatives proposed the HEROES Act. I understand that it is very unlikely that it will pass the Senate, and probably unlikely that the president would sign off on it either. So I don't think we're going to have to worry about the HEROES Act, but if it were to pass, from what I understand, and I haven't read it, is that it would limit associations' rights potentially to collect assessments going forward, which would be horrendous for the operation of associations. So hopefully that will not pass, and people will have every incentive to continue paying their assessments so that associations can continue to operate as normal. So I hope I answered that question. Do you guys, Catherine, Aaron, Barbara, Troy, do any of you have anything to add?
I would echo what you said there, Brooks. I have seen some communications by community association lobbying groups or law firms or other entities that advocate on behalf of associations, and they are advising people to call their senators. So, I see no harm in, calling the offices of Senator Scott and Senator Rubio. They're not going to vote for this anyway in its current form. The real thing to watch out for is to see, in the reconciliation process, what happens, what the Senate might take out of the House HEROES bill that passed, because the House HEROES bill that passed did include association collections with all other forms of debt collection. And I'm not sure that, I don't know well enough to know whether that was the intent, right? Did associations get lumped in with something that was not intended to be? Because people's personal incomes are stretched so tight right now, there's pressure to not do debt collection. And we see that here in the state of Florida, where evictions for non-residential evictions, non-payment, right now you cannot bring those to court. The courts are not moving those here in the state of Florida. And so, there's this movement to say, for the stability of the economy and for people to continue to pay the things they have to pay, we're not going to do debt collection. So that's part of, I think, the thinking of the HEROES Act, and HOA and condo assessments fit within the definition within the HEROES Act. So we need to watch it, but it's not an immediate concern, and there's nothing that you need to change right now.
Okay. Another question that I received. If an owner pays back due assessments the day before an initial intent to lien notice has been received, are the fees still charged to the owner? Yes, technically, if the notice of intent to lien was already placed in the mail and served on the homeowner, then the fees would still be due, and the owner was still delinquent in their payment. So there may have already been late fees assessed, there may have already been interest assessed, so that homeowner would owe the additional sums, even though they came in and paid on their own volition the day before they received their notice. But a lot of associations are reasonable, and a lot of associations might consider waiving the expense in that case. So, you know, the owners may ask, but it's really up to the association at that point, because the expense has already been incurred because the homeowner was late, even though they ultimately paid. Does anybody else have any input on something like that? No?
I think at Wright and Casey, we don't want our associations to get stuck with those bills. So depending upon the circumstances, you know, if we don't want a demand letter to go out and 3 days before the demand letter went out, the person paid their bill. You know, that creates that overlap. Again, they were technically delinquent and the fees were incurred, but we want you to be reasonable. And, you know, if you're using us as your lawyers, we typically are reasonable where maybe we'll reduce that or waive that for a single instance. Now, again, we don't want to get into a pattern of that because they absolutely owe it, and time and expense was incurred. As Brooks said, you can't eat into the principle of what was owed, but if you want to make a deal on interest or late fees or the attorney's fees, that's something to think about.
And from a best practice standpoint, before we pass a file to Wright Casey or any entity, we Southern States feels that one of the best ways to avoid that is to send a second or third notice, and in that notice clearly say, if you don't pay by May 31st, this file will be passed for, and what we technically, or what we call is, you know, advanced collection through the association's counsel or an attorney, whatever the wording is, and the fees and charges associated with them to pursue collection will be added to your assessment account and your responsibility, and they could be in excess of $200 or something, like, you know, whatever we have in those letters. And we've sent that to them in many cases 2 and 3 times in our, you know, because we have, you know, typically you want to give someone about 90 days before you send them a late notice, and then you send them a second one, and then now they're 90 days delinquent, and it's go time. And so when the attorney gets it, you've sent them in that second and third notice the fact that they're going to be responsible for those fees and charges, and we typically successfully are able to you know, resolve it in advance of it. And then when it does become a circumstance where they're disputing it at the, you know, after the fact, the grounds for the association to stand on, be equitable, non-selective, and, you know, mitigate that circumstance is in the association's favor. And as Brooks and Catherine said, the reasonably common sense, close it out type thing would be up to the temperature of the board, and hopefully there is a basis for reducing a late fee or finance charge and getting you know, the association's collection action paid in full as well.
Okay, another question sent to me, and it's similar. It says, if the notice to lien is not sent to an owner per the timeline within the governing documents, and the assessment gets paid before it is received, is the property owner liable for the hard costs? Same, I think that's the same basic question, so same answer. If the costs were incurred because of the delinquency, then the owner is still going to be liable for them. But again, there may be opportunities, you know, there may be certain circumstances that need to be considered about whether or not the association is actually going to enforce that or not. And a lot of times that becomes a case-by-case analysis. Does anybody have anything? Does this seem different to the previous question? To me, it seems the same. Yeah. Okay, last question that I have directed to me right now. What are your options if your members do not vote for a special assessment, but the board believes it is a necessity? For the most part, well, depending on what your documents say, the decision whether or not to levy a special assessment is going to be one made by the board anyway. Some declarations, some documents will provide for member input on special assessments, or they may cap the board's ability to levy a special assessment. But for the most part, the general default rule is that the board is going to be the one voting on this. The important thing, if you're the board and you're considering a special assessment, is that you closely follow the requirements, because people don't like special assessments. Usually they relate to an emergency situation or some unforeseen expense that wasn't budgeted for. And so people don't like those unexpected things, and sometimes they challenge them. And so you want to make sure that you followed all of the notice requirements required by the statute, and you know, both before the meeting and after the meeting if you approve the special assessment. Does anybody else have anything to add about whether or not the board can levy special assessments with or without owner input? No?
No.
Okay, do you guys have the questions from Diane directed to each of you?
Yes. Catherine, you want to start with yours?
And I have two questions. The first one being, if a board member has an expense that they incur on behalf of the HOA, can they get reimbursed? And I think that the specific issue here was maybe running out to Home Depot and buying something that was needed to make a repair at the HOA. Can the board member get reimbursed for that? A couple thoughts that I have on this. One is, yes, you're not supposed to, you know, go into debt for the associate. You're not supposed to incur expenses as a board member for the association. And so, you know, you can get reimbursed for that. But it's probably not a best practice to make that a routine thing that you're doing, that you should not be incurring any expenses on behalf of the association. If there's a way to do it with an association credit card, with the management company issuing a check, if it's something that can be planned in advance, if one of your vendors can make the repair for you as easily, I recommend doing it that way and taking the board member out of it completely, because, and I'm going to hand it over to Barbara Reed here, there can be questions about, you know, are you getting airline miles? Are you getting perks of a credit card, bonus points? Are you, you know, what could be real or perceived benefits of you making this purchase? Because Barbara had this come up in a dispute.
Yeah, I did have that come up. There were two board members who had used their personal Capital One cards to make a lot of purchases on behalf of the HOA, and they accrued rewards for that. What ultimately happened was those homeowners, fortunately, or the board members, fortunately, they did reimburse the HOA for the monetary value of the rewards they were getting. So that's yet another good reason to be careful about credit cards, is because you're not supposed to benefit from your position as a board member, and rewards are very much a benefit.
And so one way to avoid that, right, would be to, again, pay with check or cash, keep your receipt, make it real clear. You know, if you have an emergency sprinkler head that's spraying out all over the entryway, I don't want you holding this up to get the irrigation company out on Tuesday. You know, if you're able and willing to make that repair and can do it, you know, let's be practical and do the fix. I just don't want you getting yourself into a position where you could be accused of profiting.
Yeah.
Any other thoughts on that question? The second question I got was about a conflict of interest. Could it be a conflict of interest for a board member to chair a committee? Now, it depends on the committee, and it depends on your individual association's documents. So the first committee that jumps to my mind is the fining committee. That's a newer process clarified by statute, where The fine committee is supposed to be separate from the board, and the fine committee is going to review the board's actions and either give it a thumbs up or a thumbs down. And no one on the fine committee can be a board member or a relative of a board member or reside in the residence with a board member, I think. So it would be a conflict of interest for a board member to serve on that committee. Beyond that, I'm not sure that there are committees by statute that it would be a conflict to serve on. Your own documents might lay that out specifically. You also might want to think about the review process. So the question was specifically about architectural committee. You know, is there an appeals process in your documents? Are architectural control decisions, if they're not approved, does the board have some ability to review those? Then it might put that board member in a strange spot, making a decision, being a part of the group that makes the decision, and then being part of a group that is reviewing the decision that's made. Maybe that person would recuse, or, you know, we need to sort of think that through specifically. But any kind of committee that the board would be reviewing, I'm not sure that that is a great, whether the board member would want to be a voting member of that committee. I have some boards or some associations where board members are specifically placed on committees, that we have a board member as a liaison or as the head of each committee. So I think that's going to be really individual, but I'd watch out for the situations in which a board is specifically designed to review a decision by a committee. Other thoughts, Wright and Casey, Southern States?
Yeah, that's good.
Those are my questions. Erin?
Okay, I had one question submitted regarding Chapter 72303, and this is for records request. The question was, does a records request submitted by any other means other than certified mail meet the standard, or must the request be sent by certified mail? So I don't know that I particularly covered it, but it doesn't matter. I went to the statute to be sure before giving this answer. And so the statute, early in the statute, it provides that the records shall be made available for inspection within 10 business days after receipt of a written request, period. That's where that sentence is. Later in the statute, it provides that if the request is made by certified mail and the association fails to provide access, that creates the rebuttable presumption of a willful failure on the part of the association, which then exposes the association to potentially up to minimum $50 a day damages. So practically speaking, if a member makes a request for some documents, some information, if it is readily available and easily shareable, right, we're gonna want to provide that. We're gonna provide that. I have had a couple of instances with my active owners, right? Well, they'll request something, we'll provide it. They'll request again, we'll provide it. At some point, though, I have, responded to an owner and saying, okay, I believe that we've provided everything that you're requesting, or maybe I'm not clear on what the request is, frankly, anymore. Then I will always respond back to the owner. I will make sure, I will recommend that the board, someone needs to communicate with this owner. You can't just sit back and ignore it, a request. Ask for clarification. Be sure you understand what they're asking for. If you think you've already provided, at some point I would quote the statute later that does reference the certified mail. So anybody have a different opinion on that?
I mean, the whole point is that owners are entitled to the records, and their remedy, if you don't give them the documents, is they can seek a monetary penalty against you. So like Erin said, you want to just establish that you have attempted to answer their questions. Sometimes you get questions that aren't clear, so you want to show that you've made every effort to make sure you're answering the question that they wanted you to answer and get you the documents that you wanted, so that later, if a judge is looking at it, you can say, I tried, Judge, that we tried to give them everything they asked for. And so that's, I think Erin's point is well taken, that you want to show the effort. You want, these people are entitled to the documents, so you need to play along, even if they're that troublemaking owner that makes a request every 3 months. You need to participate and not just put it on the corner of your desk and forget about it, because that's where the association will accrue some liability for not doing what it's supposed to do.
And real quick on the management side, from a best practice standpoint, we're always cheerleading and advocating transparency. We made an investment in technology, and we have an owner portal. And so we're always attempting to put as much information, minutes, and all of the materials that would easily be able to point a member asking for something, say, hey, it's right there, it's always there, here's our routine for updating it, and here's why we don't put draft minutes out there until they're approved, and that eliminates an enormous amount of the annoying, hey, I want a little bit of this, a little bit of that, where's this, where's that. But if you get that routine going and owners have access to it in the middle of the night when they are thinking about it or they're concerned about something, they can log in and see it. And so we found that as a best practice, just try to advocate transparency and a routine to keep the association information available for the membership to review if they want. And then special stuff, you can navigate through that pretty easily.
Okay, well, I think that concludes the session. Just want to thank everyone so very much for their time, especially Wright and Casey. For those that want more information on them, please visit them at surfcoastlaw.com, which I think is so cool, surfcoastlaw.com. DaytonaPropertyManagement.com is where you can get more information on Southern States. It's also where we post a number of educational opportunities. We have forums, we have virtual meetings like this, certifications, and we will be making this video available. Brooks, we got a comment from one of our board members saying how great the materials were and the content, and had wondered if we could make that available online. So we'll regroup about that afterwards, but at the minimum, we'll definitely have this video on our website. I will be emailing the link that you can share with your other board members to everyone. And Wright and Casey will be emailing you your certification. Is that correct? Yeah, shake head yes, everyone, for Wright and Casey. Okay, good. Oh.
And could I say, so if you have other board members that want to watch the video, unfortunately, they won't receive certification from us because you had to be here in person. But if, it's definitely an educational thing they can watch if they're just looking to brush up. Thanks, Diane.
Thank you all. If there are no other questions, we'll go ahead and wrap this up, and we appreciate everyone's time. Have a great day. Be safe.
Bye-bye.
Bye.
Thank you.